Hi guys, it's Kathy. I hope you're doing well. I hope someone told Fozzie I was streaming right now because last time I streamed without telling him, he said I streamed without telling him. Nope. No Fozzie, no Kelly. Hopefully they're sleeping, getting some sleep. What do you mean be right back? No. Micah, I just started. What, am I not entertaining enough? Hell in a handbasket, guys. See? That's my son. He's playing Overwatch. And believe it or not, he's really good. He's like top 5%, top 2%. So, hey Jamie, how are ya? AKS. So, I did my stream for tonight a couple hours ago. So, as soon as I was done with that stream, I found some stuff for today right now. Hopefully it's good enough. Sometimes some days good enough is good enough, guys. And that's fine. I'm going to go with Judge Reese first because we go along with it's a jury trial and they're done for the day. We're not doing the whole jury trial because first off, the whole trial's not done yet. And I don't want to do any trials anymore until I have an answer. Um, so I don't leave you guys hanging. So the trial's going to finish on Thursday. And I don't even know if the trial's good enough to show you, but this part is. So today they did jury selection, which I recorded, did not watch. I heard a lot of laughing in the background though. So I think they had good time doing jury selection. I don't know. I'll have to check it out. I don't want to check it out. You know what? Maybe I'll send it to someone else to check out for me who wants to watch a jury selection. See if it's good. So there was one part of it that was pretty good. We're going along, we're fine. They're done for the day because they're out of witnesses. The next witness isn't until Thursday. And we hear him giving jury instructions and all the normal stuff. And then this happens. And then out of the blue, this happens. So we're going to watch this. What else are we going to watch? We're going to watch a pro se. We're going to watch a case that's a little hinky. We're going to watch a shitty case. It is shitty. That's why I got it. Hi, Constance. And then we're going to watch a pouting attorney, which this last one might be a little bit too lawyer-y to keep your attention for the whole thing. But I liked it. I enjoyed it, so I'm showing it. Let's start with pro se, though.
Come on up.
Your Honor, for the record, I'd like to reserve
What-
my rights
what-
at all times.
Okay.
Wavering none.
Say that again.
I'd like to reserve my rights at all times, wavering none.
Just so you know, the first thing this guy is about to do is waive some of his rights.
And you have rights, and your rights will be preserved. We'll make sure that they're protected.
Thank you, sir.
Any information in this case yet?
No, Your Honor.
Want to move this to December, our next arraignment docket?
Yes, sir.
All right, Mr. McDonald,
Object.
one moment. Let me. Do you object to moving this to the next arraignment docket?
Absolutely.
What's your objection?
The objection is the defendant. I believe they have 40 days to file the case.
Okay. Where did you get that from?
Is that not correct? I believe it's in the Florida rules,
Okay.
Florida criminal procedure. 40 days from the arrest.
That's not the case.
There's not a case. Okay.
Yes, sir. They can file information up to the speedy trial period. The 40-day rule about which you're speaking is for individuals in custody, that if the information is not filed within 40 days, you're in custody, then you're released on your own recognizance. Any other objection to moving this case to December 10th?
Yes, sir. I'd like the motion to dismiss just based on procedural matters. I've sent.
Again,
You're saying nothing's been
nothing's
charged.
been filed, so
So
there's nothing to
to
dismiss.
talk about.
There's nothing to dismiss.
I understand.
If an information is filed, then we'll go through your right to counsel, whether or not you want to seek the office of a public defender or represent yourself or hire counsel. In fact,
Nah, he already came to one stream today. That's pretty much all he's good for, once and done.
I'll do that now. Although an information has not been filed, you do have the right to an attorney. You can represent yourself. You can seek the services of the public defender's office, or you can hire private counsel. How do you want to proceed, Mr. McDonald?
I do have a question. How many more times can this go forward as far as the arraignment and then, okay, nothing's charged and then continuing like that?
That's a question that you can answer and ask an attorney, and they will be able to answer for you.
Okay. I'll look that up. Thank you, sir.
Okay. So any objection to coming back December 10th?
I do have an objection.
Okay. Are you going to seek private counsel, or are you going to represent yourself, or you want the public defender's office?
I'm going to represent myself.
Okay. You raise your right hand for me.
Yes, ma'am.
All right, Mr. McDonald, I have to confirm that you are waiving your right to counsel, and that you're doing so knowing, intelligent, and voluntarily, and also you understand the disadvantages of self-representation. Do you understand that you have the right to an attorney,
Yes, sir.
and you're waiving that right?
Yes, sir.
Are you under the influence of the alcohol, drugs, and medication?
Excuse me, Judge. The first thing he said when he came up was he is not waiving any rights. None. Zero.
Anybody promise you
But
anything to
then-
get you to waive?
You have to waive a right because you have a right to an attorney and you have a right to represent yourself, and you can't have both. So you can't not waive any rights, sir.
Is that right?
No, sir.
Anyone threaten to coerce you in any way?
No.
And as far as the disadvantages of counsel, what's your highest level of education?
College.
What, did you complete college?
Yes, sir.
What's your degree in?
Nutrition.
You read and write the English language, I assume?
Yes, sir.
Have any legal training?
His degree is in nutrition, so don't worry, he got this.
Do you have any legal training?
No, sir.
Do you understand the rules of criminal procedure?
I'm reading up on it.
Reading up on it?
Yes, sir.
You understand the rules of evidence?
I got a book.
Reading up on that as well.
Reading up on it?
Yes, sir.
You understand that an attorney licensed in Florida understands the rules of evidence, understands the rules of criminal procedure, understands when information should be filed, and if the information is legally insufficient, what motion they can file to challenge that. You understand that?
I do.
You understand that without an attorney, I'm going to hold you to the same level as I would an attorney in this case? You understand that?
Yes, sir.
Do you understand that I cannot help you out? I cannot answer any of your legal questions. I cannot give you any legal advice.
Yes.
Do you understand that you are at a disadvantage by representing yourself when the assistant state attorney has been doing this for almost 20 plus years? And that if you want to seek the service of the public defender's office, Mr. Brian Hill has also been doing this for decades.
Kelly, I know how stressed out I get when you say you have an inspection coming up. I get really, really, really stressed out. And I'm not even you. So I can't imagine how stressed out you are right now. It's just not right. What they're doing is not right. And there's nothing anybody can do about it.
And understands the rules of evidence, criminal procedure, and the law in the state of Florida.
Yes, sir. I understand. Thank you.
And you understand those disadvantages of self-representation?
Yes, sir.
Do you want to go forward representing yourself?
I do.
All right, I'm going to find your waiver of counsel is knowing, intelligent, and voluntarily made, and that you understand the disadvantages of self-representation, and you're making that decision. And we'll go forward to December 10th. I'll overrule your objections. We'll move this case to December 10th at 9:30.
Right.
Kelly, it's terrible. I want to do something. I want to get you out of there. I want to, and I know that I can't. Okay, this next case is a little hinky. Just a little hinky. I would be livid.
Joseph Son, oh, we already called him. Let's try Terrence Scott.
How you doing?
Hi, what's your name?
Yes, kinky. That's what I said.
Did you watch the video today, sir?
Yeah, I did.
Any questions about your constitutional rights?
Yes, ma'am. So I feel like my constitutional rights have been violated. I can get a second to try to explain. Okay, so I was charged with 2 counts of violation of a protection order last month. I came back to advisements and they told me that I was supposed to go back in courtroom C on 11/4/2024. Okay, the attorney came and seen me before the 4th. That's in Division C, and told me that they changed my courtroom back to Division B. So they changed my court date from the 4th from 11/4 to 11/5, and I was no longer in Division C, and I was put back into Division B because that's where my charges were from the beginning. I went into court 11/5/2024, and I got the protection order modified. That's the paperwork in my hand. I don't know why they're saying that another division is on my thing and that is separate from Division B, but I got the protection order modified on the 5th of this month. I was told by the judge and me asking more than once if I was allowed to have contact with the victim. And I was told yes, and the protection order was modified. So if that's why I'm here today, I'm not understanding why.
Okay, let's see if we can figure this out.
Yes, ma'am.
I do see the transfer you're talking about from Division C to Division B.
Yes, ma'am.
And for council's reference, I am currently looking at 24M6251. The minute order the minute order from November 5th does not reflect any information at all about the protection order. The only protection order in the file is the original protection order signed by Judge Ankeny and the defendant on October 21st that did have a no contact provision.
Yeah.
So let me, hold on. So let me check the other case before.
All right, this is the one she's talking.
Okay, so now I'm looking at 24M4192. And in that case, again, I do see it's in Division B. I do see an amended protection order. And that does lift the no contact and the vacate the home provision. So what I'm showing.
So just so you know, I was playing Skyrim when I was recording this, and I thought that I had turned the volume the whole way down, but I can hear Skyrim in my head, so I know that I failed. So that noise in the background is me playing Skyrim.
Showing is that the protection order was modified in one case, but not in the other case. So I certainly understand why you may have been confused. And oddly enough, there is no minute order. The protection order, the amended protection order was filed on November 5th, but there's no minute order from November 5th in that case, which is weird. So, sir, I certainly understand your confusion. And I think this is something that you'll have to hash out with your public defender. It looks like you do have Ms. Lindberg representing you from the public defender's office. And okay. So here's what I can tell you, sir. You are facing at this point at least one count of violation of a protection order, Class 1 misdemeanor. You do have those two cases in Division B holding you. You also have a parole hold for a separate case. So, based on the protection order not having been modified in 24M 6251 for whatever reason, I am finding probable cause for the violation of the protection order charge, in this case, 24M 6670. Do we have Kelsey Berg on the line by any chance? Has the district attorney's office heard from Ms. Berg today?
Yes, Your Honor, and our understanding is she would be on WebEx, but we otherwise have no comment from her.
Okay. Do we have Kelsey Berg on the line?
Don't call him a senior.
Okay. Apparently, we never got any requests for her to log on to WebEx today. So, Mr. Chino, did you want to weigh in?
Well, I mean, I'm looking at the same thing the court's looking at, and I do believe that there could be a basis to challenge these charges. I understand where the court's coming from in the sense of finding probable cause at this very early stage. And what I'm trying to say about that, Terrence, is that it sounds like if we could get Brianna in there to talk with you, address this with the court, it seems like this was could be, I don't want to speak definitively here, but it could be a clerical error. And if that is the case, that is something that can be fought. I mean, of course, every case can be fought, but it sounds like that you'd have substantial grounds to be challenging these charges. But I do see that you've got some no bond holds out of that same courtroom. So if I got you a PR today, if we argued for a PR, you wouldn't be released due to the parole hold, the no bond holds.
If he doesn't look like 1970s, I don't know what does. So no, he doesn't like mood lighting, but I bet he digs lava lamps.
So my request would be, Judge, for bond to be set in this case, right? Because it's at a no bond hold, for bond to be set. But for us to be able to reserve arguments for reduction in bond when we can address the parole hold, these two other courtroom B cases, as well as this present case.
I think that makes sense.
She
I
looks
am going to set a
1970s
bond
too.
today, and we'll set a protection order as well. The protection order can be modified in Division B, and your Division B court date is going to be on the 14th. So that's coming up real quick, just a few days, okay? So at this point in time, just to be consistent with 24M 6251, I will impose that no contact order with Ms. Berg. So that's going to be in place for now, okay?
So what does that mean? Okay, it means that he had two courts that gave him a no contact order, okay? And then one of the courts lifted the no contact order, so he contacted. Well, he's in jail now because the other court didn't lift it. So now that he's back here, he has a defense. He might be able to get out of this, except she just put the no contact hold right back on him again.
But what I'm saying is that all of this should be addressed again on the 14th in just 3 days in Division B. And I may reach out to Judge Fennick and just kind of lay all this out because it is a little confusing. So it will be in place for at least the
Boring.
next 3 days, but it can be addressed at that next court date. And then for the bond in this case, the court is going to set a $500 cash surety or property bond. That's the same bond that you have in 24M 6251. So I'm going to be consistent there. So sir, are you acknowledging the terms and conditions of the protection order?
Yes, ma'am.
Okay. Just checking one more time for Kelsey Berg on the line. Okay. All right. So as I was hinting at, your next court date is going to be November 14th at 10:30 in Division B. And that's going to be the court date for all 3 cases, right? The new one for today and the 2 other ones that you already had. I'm not going to make a finding of force. Did I miss anything? Okay. Any questions, Mr. Scott? I obviously can't dismiss the case today. I do understand your concerns. I do understand some of your confusion, and your counsel today has acknowledged the fact that there is something a little hinky going on that we'll try and get squared away in Division B. Okay? All right, thanks.
Yep, that's him. That's who they're talking about. All right. This is going to be a shock to you what I got here, guys, but it was a shitty case, and I love shitty cases. So I got it. You probably already seen it. It's okay.
14A District Court of the County of Washington, State of Michigan is now back in session. The Honorable Judge J. Cedric Simpson presiding.
You may be seated. Court recalls the case of Strong Future Homes versus.
Just because I don't get Judge Simpson does not mean I can't get Judge Simpson.
Cochran.
Can't speak for the plaintiff.
Okay, and where are we now in this case?
Kilos 875.31. I checked, the plumbing issue is caused by the next door neighbor flushing wipes. The plumber is there now. They've responded every time it happens. Ms. Kim asked me during the break whether Ms. Cochran could move. Apparently she's overhoused, and the answer is yes, she can. They just don't have a one-bedroom unit available right now. We made a settlement offer last time. I confirmed today that the offer is still available if we can get this resolved. And Judge, other than that, I don't know what to do except make this the first trial I've had in front of you in 20 years.
Your Honor, as I've told Mr. Fink numerous times, this is not about the rental balance for Ms. Cochran. Most of that is because she was charged for bedbug treatment, which I think is inappropriate. But regardless of that, it's about her having to live with sewage backups continually in her home. And
What if
This isn't a tenant case. This is a poop case. She's filled with poop.
the cause is
Full
the
of
neighbor?
shit.
What would you suggest that they do other than respond?
Your Honor, I don't know if this is true. I've asked for information regarding the contractor so I could speak to them. If you would be so kind as to allow that little bit of discovery, so maybe we can put an end to coming back
No,
repeatedly on this.
we're gonna put an end to coming back. But it's not gonna be by that mechanism.
I don't know, Your Honor. What would you do if it's the neighbor causing the backups?
Well, that's gonna be the problem. I mean, it seems to me that well, let me ask this, and the real issue, it seems for Ms. Cochran, is she wants to move.
Well, she doesn't want to live this way. Your Honor, she showed me a picture of.
Right. I know, she doesn't want to live this way, but if it is indeed the neighbor that's causing the problem, it sounds to me like if she's overhoused, then
Kelly, you'll be fine.
she can move as soon as a one bedroom becomes available. Would that be the case, or is there? So,
Your Honor, I promise you that there is no one on the landlord side of this case that wants to prolong this or Ms. Cochran's tenancy in that unit at all. And I checked when asked today.
If it's yellow, let it mellow.
Would like to move, but I checked and the answer is they do not have a unit available, but yes, she can move when there is one available.
okay,
She has been repeatedly making the request with plaintiff to
to
move.
move. But her unit now is what, a
2 bedroom.
2 bedroom?
She had children that grew up and left.
Okay, so the real issue is if they don't have a unit, there's nowhere to move her. Right? So why couldn't there be an agreement that the first one bedroom that becomes available, she can move? And then resolve the dollar fee? Because otherwise I don't know what we're fighting about.
Well, Your Honor, she just showed me her phone record and she has been calling the rental office repeatedly for days. And they are just now addressing this issue. She's
Which
had
issue?
the feces all over her house, the sewage all over her house. You know, I understand yesterday was a holiday and it was a weekend before, but in an emergency situation like
So what do
this,
you want to come out of that?
well, I guess it's not just Miss.
It would be a nice thing if she could just have a poop-free environment. Judge, no poop. We just don't want poop. Is that too much to ask for?
Cochran's case, Your Honor, I believe that this property has insufficient maintenance. They're not properly taking care of addressing their repair
I'm
requests.
not here. to
I
address somebody's
understand.
business.
Uh,
I'm just not. I mean, I've got Miss Cochran's case in front of me. She wants to move. They don't have a one bedroom. So I don't know why the agreement can't be that when a one bedroom becomes available, she gets it. I mean, that's gonna be the best that anybody's gonna
Well,
be.
Your
The neighbor keeps flushing wipes down the toilet, so I've heard. So it keeps getting clogged over and over and over again. It's getting clogged.
Honor, I think in addition to that, because who knows, it could be a year before she gets another unit, is that if there's an emergency maintenance issue, that they respond within 24 hours. She shouldn't have to live.
Well, right, but the definition of what's an emergency, it's gonna be whatever it is, but I mean,
That's my baby boy apologizing to y'all for swearing in the background.
I believe a sewage backup that's affecting her whole unit is an emergency. And that she
but
has,
when did the call, Mr. Fink, were you able to determine when the call went in?
It began this past Friday. And the message I have is the issue is being resolved. There's a contractor there now, I believe. So Ms. Kim asked me if it was an employee or a contractor. I don't know why it matters, but the answer is there's a contractor there. Issue is being resolved and has been each time she has reached out. So I remember that Ms. Kim mentioned on behalf of Ms. Cochran that it had happened more than once. They've addressed it every time it occurs. But it happened this past Friday and the contractor is there now.
No, that's horrible. The Dutch need their poop shelf. Don't take their poop shelf from the Dutch.
So. Wow.
No, I think like legally they changed all the toilets to what, like 1.5 gallons? I don't think you can buy 3-gallon toilets anymore, can you? Or is that just Pennsylvania? What is a gallon?
So the question I have is what would you have the plaintiff do?
respond to stuff immediately. And Your Honor, I would really like to have a conversation with the contractor to understand what is fully going on. And I believe that
If that's
plaintiff is telling Mr. Fink what they're telling him, but I would like to have a conversation with the contractor.
Well, but.
No,
but
it's
Ms.
not.
Kim,
He has no
something
right.
Had to occur.
He can have rights when he pays for stuff. He's not watching anymore. He's back. See, he's back yelling at 15-year-olds.
I don't think it doesn't sound to me to be a defect in the premises because it passes inspection on the 1st of November, right? And then by that Friday, there's this problem. So passes it on the 1st, I don't have my calendar here, but passes it on the 1st of November, that Friday. And then by the 8th, there's a problem,
Your
which
Honor.
is then getting addressed by the landlord this morning.
Ms. Cochran's phone history wouldn't go back further, but the calls all started from the 4th repeatedly. So
Fourth.
she's been calling for over a week before they responded.
So how would the parties define immediately?
Well, I would say within 24 hours, Your Honor, most,
She will say within 24 hours. He would say, look, I'm getting to it. Don't remind me. You told me 6 months ago and I'll get to it.
emergency maintenance staff are available to respond within 24 hours.
To an emergency.
To an
Two things
emergency.
have to be defined. What's an emergency and then the response time for a particular thing. I mean, I get that she's saying she calls, they're saying that the issue arose Friday. The issue also doesn't come from Ms. Cochran, it's coming from somebody else.
Well, maybe those little bastards deserve it. Maybe they should stop spawn killing him.
It's also not, at least as they're saying, not coming from the landlord. So somehow or another, this has to resolve itself. I mean, because right now, frankly, Ms. Kim, if the unit passed inspection and then there's a delay, if I even go with your facts, she calls on the 4th, which would have been Monday, and they respond within a week. What are her damages?
Your Honor, she has.
What are her damages? No, I mean, realistically, what are her damages?
Well, Your Honor, the landlord has a duty to provide her with a habitable home. And if she had
Correct.
feces in her kitchen
And but
sink,
hold on, they did. The landlord, however, is not the guarantor for everything that occurs. So she may have a dispute with their timing. Get it? What are her damages in regard to that? Because if the unit passes inspection on the 1st, she's calling that Monday. The landlord gets notification or at least has some acknowledgement of that by that Friday and has somebody out that following Monday. Yes.
I just want to clear up one thing. It's my understanding, and Ms. Cochran can tell us, that today is not the first day someone's been there, but that it happened again. And so someone is there today. In other words, it didn't take a week. There's been one or two reports, from Ms. Cochran that received a response. That's my understanding. I'm not trying to put.
Well, and that would make sense because that, as Ms. Cochran said, it's happened 2 or 3 times since. And that's why I wanted to.
I just want to make it clear that it wasn't a week delay in responding.
Your Honor, the problem is whatever the source, she's not being provided with a home that she can live in safely, especially with her medical condition.
Let's say
And
you were able to sustain that. Because as of the 1st, with the inspection, she has been. Something happens on the 4th, and it is going to be a battle, or whenever that occurs, then it's going to be a battle of who the court believes regarding a call than a response. But the parties aren't that far off. They're acknowledging that there was a call. The question became, when was there a response? There's a response. Then something else happens. And it happens then on that Friday. They then get a contractor out by that Monday or Tuesday because of the holiday. So then I get back to the point of what are her damages in those interim times. I can't say, if true, that she called in and somebody came out, that there wasn't a response from the landlord. But if the landlord responds, abates the problem for whatever period in time, even if just for a little bit, but the cause of that problem continues, that's not on the landlord. It's on this other party, if that's the cause.
Well, Your Honor, if I may, if there is a cockroach infestation in the building and it was caused by one of the neighbors, I mean, the landlord's still under obligation to remediate that. And even before this most recent
But
incident
hold
of,
it, that doesn't apply in this case. Because what would apply in this case is there are cockroaches in the building. Landlord comes in, brings an exterminator in, gets rid of all the cockroaches. Then the neighbor, brings a batch of new cockroaches in. The landlord still has to respond, but the landlord isn't the reason that's occurring.
well, I don't know, Your Honor. We're just taking, we have no evidence. That's why I'm asking for
But Ms. Kim,
information.
what I'm indicating is even if everything you're saying is correct, what are her damages? And then what remedy do you want? Because I'm not hearing a remedy. I'm hearing the complaints. I'm not hearing the remedy.
Well, first of
Because
all,
if it's going to be responding immediately, okay, put that language in. You guys will be back when there's a response. And then we're going to be trying to figure out what immediate is.
Your Honor, so this is not just about what happened after the unit passed inspection. This case goes all the way back to when Ms. Cochran moved in 4 years ago. There's a whole list of repairs that she requested for 4 years. They completed out the repair in the system as though they were actually fixed when it wasn't. That's fraudulent. And it was only after the city, we called the city to show that none of it was actually done, did they go out to fix all the problems in her unit. And she didn't have a working washing machine, dryer, or dishwasher all these years, and they never fixed it. There's so many things, Your Honor. It's not just about the $700.
So we
She's the
want
tenant.
To just set it to trial.
Your Honor, I would like to plaintiff to recognize that they've been attending to their duties very poorly and try to make an
How would
agreement to do
like-
better.
How would you like them to recognize that, Ms. Kim?
Well, Your Honor, I think that what we're suggesting about timeliness of response is one thing. And I would like to be able to talk to the contractor to make sure it's not a more systemic plumbing issue. You had suggested I call WCC to maybe get a pro bono structural plumbing person. Nobody's called me back. So if I could actually just speak to whoever they've hired, I think that we could maybe come up with some.
They're out there now, Mr. Fink, from your understanding?
That's my understanding.
All right, I'll adjourn this out a week. Go talk to them. I still don't think we're gonna get anywhere. I mean, I don't know what you want the landlord to do. Because particularly if it is caused by the tenant. And when you talk about a systemic problem, I can have certain size plumbing. If somebody's putting something down there, depending on what plumbing I have, it may not be a problem.
Told you it was a shitty case.
But that doesn't mean that there's an issue with the unit.
Your Honor, is it not?
Your Honor, may I have 30 seconds?
Sure.
I'd just like to point out that this is the third or fourth time that we've been back, including Ms. Cochran, who has to come to court every time this happens. We can come back next week. If we have a final settlement conference, I don't expect
If
the
it doesn't
landlord.
resolve, then I'm going to trial.
And so I would like to ask for a trial date now instead, and point out that we have offered to
No,
remove
no.
the fee that was assessed to Ms. Cochran for not preparing for the pest treatment, which would take her down to, I think it's $435 or $475 and some change, less than $500. And we know that there are funds available to her. My client had offered to give her till the end of the year, to December 31st, to pay this less than $500, which means this case could be resolved. But I'll do whatever the court says, including come back next week and then come back for a trial. But I don't expect anything to change, especially now that we know that this isn't about whether she owes $435 in rent and court costs. It's about something that happened 4 years ago.
It's not about something that happened 4 years ago, Your Honor. It continued for 4 years. And honestly, Ms. Cochran should be entitled to damages for plaintiff's neglectful duties. But Your Honor,
What time next week, Your Honor?
9 a.m.
Thank you.
And this will give you an opportunity to go talk to the contractor. And
I'm not allowed to say anything. How can I talk to myself? Why? Connor? All right. Thank you. Okay, good. Thank you, Your Honor.
you're welcome.
Your Honor.
I don't think the sewer problem has been going on for 4 years, because that would be a very slow growing baby. I think everything has been going on for 4 years. She has that she wants fixed, and who knows, maybe they really are, issues that should be fixed. But this attorney, he kept asking, what are the damages? What are the damages? What do you want? What do you want? And she gave nothing. Hi, I hunt you. Okay, CJ, are you really gonna pull out a Savannah accent? That would be epic. An Australian Savannah accent. What's next? All right, we're gonna go to Judge Reese now and his jury case. So where we're at, he just spent the morning listening to witnesses. All right. And there are no more witnesses available today. And this happened yesterday. So he's breaking until Thursday, because the next witness isn't available until Thursday morning. We're not watching the case. We don't care why he's there. We don't care about the charges or anything. He's about to give the jury instructions and let the jury leave. And I'm just going to say it for you all now. Oh my God, we see the jury. Oh my God, that's not legal. Oh, there, I said it for you. You don't even have to make a comment. We get to see the jury leave, and then that's when it all goes down.
14A District Court of Washington State of Michigan is now back in session.
Or I'll click the wrong button and we'll do a shitty case all over
Court
again.
recalls the case of Strong Future Homes versus Cochran.
There we go.
All right, ladies and gentlemen, as I had anticipated, there is one remaining witness who, because of scheduling problems, cannot be here until Thursday morning at 9 o'clock. So that was always the plan, was to come back Thursday morning at 9 o'clock to finish the evidence. And once we've heard all of the evidence, then we'll proceed with the rest of the matter. So we're closing a little bit early today, but of course the jury selection took less time than I thought it would. I thought it might go to 1 o'clock, and we didn't get to start till 2 o'clock. So you never know. Those are matters that are impossible to predict. But in any event, you're going to get to go home a little bit early today. And we'll be back here Thursday morning. Tomorrow's Wednesday, and Thursday. Not Thursday week, this Thursday, the 14th, is that right?
Yes, sir.
The 14th at 9 o'clock. We'll start back at 9 o'clock again, Thursday morning, the 14th. It's convenient for me in that it also allows me to be in Emmanuel County tomorrow, where I have scheduled hearings with a number of cases on that calendar.
Guess what I'm going to be recording today?
However, if the witness was here today, we'd go ahead and finish, or if it's here tomorrow, we do that. But in any event, all that works out. Please remember the instructions that I gave to you. They're more important now than they were earlier. Do not discuss this case with anyone. Do not allow anyone to discuss the case with you or in your presence or in your hearing. If anybody tries to contact you about this case, you immediately call the sheriff's department. Let them know. They'll get in touch with me and we'll deal with that matter. Try to find out who they are if someone does try to talk to you or try to contact you about it. If you hear conversation about it, walk away from the conversation. Likewise, do not try to do any independent research concerning these charges. Don't try to go on the internet, look up all the law. I'm going to give you all the law that you need at the appropriate time. It'll give you everything that you need to hear or have to make your decision in this case. So I'll provide that to you at the appropriate time after the evidence is presented and after the attorneys have made their closing arguments. If you have difficulty Thursday morning, you wake up, you got a flat tire, your car won't start, somebody took the car, you didn't expect they were going to take the car, call the clerk's office or call the sheriff's department and we'll get transportation arranged for you. I promise they won't put you in a deputy's car that looks like you're hanging, that you've been arrested and sitting in the back of a police car. We'll get you transportation to get you here. We've got your best contact information. Now, understand, we can't start till all of you are here. So if you're late, you're going to make everybody else late. So you're all responsible to each other to be here on time. If you would, try to be here about 10 minutes till 9. I'm going to meet with the attorneys this afternoon, some more after you leave to go over some things that I think I need to go over with them. If there are other things that need to come up, I'll meet with them before court on Thursday morning so that hopefully we can start promptly at 9 o'clock on Thursday morning. Any additional instructions requested or any objection to the instructions given on behalf of the state,
No, Your Honor.
on behalf of the defendant?
Other thing I would hope the court could add to that, Ms. Wright and I can't speak to the jury either because we're
Yes.
not to have.
If you
it's
see them
nothing
in the
personal.
hall and they don't speak to you, don't get mad at them because they know they're not supposed to speak to you. They're not supposed to even say good morning or this afternoon to you because that would give the appearance of impropriety. So they know not to speak to you. So if they pass you by in the hall and don't speak to you, don't get mad at them.
Let him sleep. He needs sleep.
Say, well, they've been told not to do that. And that's true, of course, for them and any witnesses and anybody on their staff. They're not supposed to have any contact with the jurors. Okay, with that.
Kelly, it's a nightmare. That was all a nightmare. But you know what? I think we're focusing on the wrong thing right now, right before your inspection. Remember the last 4 inspections you had this year? Remember how they were fine? That was just this year. You really couldn't have really just screwed everything up that bad since your last inspection, because your last inspection was like a day ago. It felt like a day ago. You're going to be fine. You really will.
You're free to go. And if you want to leave your notes in the jury room, you may do that. Give those to the bailiff, put your name on them. He'll preserve them and give them back to you when you get back here Thursday morning. That would probably be the best thing because you shouldn't have those with you at home anyway. So give those put your name on it, give it to the bailiff. He'll keep it up, keep up with it, have it ready to return back to you Thursday morning. All right. Thank you all very much. With that, you may be excused.
Here we go. That's the jury. Oh my gosh. Oh my gosh. We can see the jury. That can't be legal.
You come on around and talk to her. Is that a juror talking to the family?
Here we go.
Is that a juror in the plea? Are you a juror? What's his name? What's your name, please? Come right over here. Wait just a minute. Stand right there. The other jurors leave. All right, Mr. Brown, you're one of the jurors in this case, is that right? All right. And you, as you were leaving the courtroom, you appeared to be very friendly with and talking with the people who had identified to me as the family of the defendant in this case. Is that correct? Who were you talking to? Who's your friend? Collier? I don't know, my understanding of those are part of the defendant's family. They were referred to by Ms. Bell as being part of the defendant's family a few minutes ago when she was talking to the jury. She said his mother's here, and he pointed out the people sitting right over there as being his family. Now, you were asked if you knew him on voir dire, and who is she to him, as far as you know? You don't know. Well, you may be excused. We'll see you back Thursday morning.
There really is his mother right there.
Do we know his entire name? They were all sitting together. This individual, you're sitting with your.
I thought I identified her incorrectly.
Well,
apparently she is the mother. So.
Who did you identify? You see, there were three people sitting there, those two ladies and this gentleman. You identified some of them as being his family.
That's his mom. It's Owen.
All right.
He don't know us. He don't know us.
Well, then why did he stop and talk with you?
He know her.
All right. And who is she? And who is she?
That's my daughter.
And she's and what is she to him?
When he left, I know him.
This is
I didn't talk about that.
you're the defendant's sister. You are the defendant's sister. Okay, so the juror stopped going out of the courtroom and was talking with the defendant's sister.
You just asked her how she was doing.
I understand that, but that's inappropriate.
Well, Your Honor, it's also important to note that in voir dire, they were asked, like, do you know this defendant in the broadest sense? Do you know any of his people? Do you go to church with him? Do you know anybody of anybody?
Y'all research the law and see if you have any motions you would like to make Thursday morning.
Yes, Your Honor.
But this is something that I personally observed as the jurors were leaving the courtroom. He stopped there and was talking to the three of them, including the defendant's mother and his sister.
The state would be preparing at this moment to actually excuse him, Your Honor, and put in the alternate.
You look up any law you can find this.
Yeah, unless they talked about they didn't talk about the case. It's a
Doesn't
small
matter.
town. Hello, how are you?
If he was questioned on voir dire about did he know any of the defendant or any of his people, and he denied knowing any of them, and then he's obviously does know them, and because you turned and pointed them out, and
I'm not arguing.
understand. You don't know him, okay, ma'am. You don't know who.
I don't know this man.
I understand that, but you're telling me that he stopped and talked to y'all even though he doesn't know you? I don't believe that. I'm sorry, but I don't believe that.
He don't even know they're my family.
And she's the defendant's sister, right? She is the defendant's sister. Yes.
That's her brother.
Right, that's what I thought. That's not appropriate.
Don't do it again.
He just asked how she was doing. That was it.
All right, counsel, you may be seated. Let's talk a little bit about the charge. The only remaining.
We don't need to hear about the charge because I don't know if this is good or not. I don't know if this trial's good or not. I haven't looked at it yet. I'm not going to waste your time if I don't get an answer, but I am going to see to Thursday morning what happens with the juror. I bet he's out of there, gone, or she, or whoever it was. I bet he's out of there. There's nothing they can do. Nothing else they can do. Okay. I think it's time. Just let me double check. I think it's time for some bad news. Not really bad news, just bad news. Pro se, shitty case. Oh, no, we still got the pouting attorney to go through. Bad news in a little bit, just a little bad news. So, you guys might want to start up a lively chat going because this 20 minutes long might be a little too lawyery for you. I just liked how this attorney is pouting the whole time. Okay, so what this is this is a an attorney is on trial for bad conduct. All right. We don't get into the whole case with the attorney right now. Um, this is just a conference before the trial. So we're not going to get into details of what this attorney did that was so bad or not so bad. The lawyers are just bickering about, just lawyer stuff for this. Yeah, ethics. He did something ethically wrong. I don't think it's not a criminal trial. He ethically did something wrong, and they're trying to see if he needs to be suspended or disbarred or whatever. So the lawyers are just talking about different motions they have going on, and there's the tiniest problem, I think, with his name is spelled wrong, or the year he started practicing was off by 1 digit or something. So, and this was in the complaint that this 1 digit was off or whatever. So the one lawyer, all he wants to do is fix it. All he wants to do is fix it. And that turns into a whole big mess. And that's all we're looking at today is this one little digit or his name wrong or something like that. Nothing else. And I'm going to click the right button this time. Don't worry. I'm a professional.
Kaminsky.
Yes,
Okay.
just one moment here.
So this is the lawyer who has ethics issues. Okay. This is the lawyer who is the lawyer for the ethics committee. So he's the one that's prosecuting this case. This is the chairperson. This is the other person. These are the 3 board members. Can't remember. I think she's the court reporter. So he's the one in trouble. He's pro se. Do you call them pro se if they are lawyers? He's defending himself, even though that's a stupid thing to do. He is the lawyer against him. And this is the panel of judges that are going to find out whether they're going to, disbar him or suspend him or find him innocent. Who knows?
Ooh, and then they pop back. All right, sorry about that. I'm having a little bit of
No
trouble getting
worries.
everyone to stay
No
where they're
worries.
supposed to be.
You're good.
Over here.
No, she's not. Disbar her. Now we have to do a whole new conference for this court reporter because she's wasting our time.
All right. Could we first please have Mr. Blessing Nelson and Mr. Glenn put your appearances on the record?
Yes, Austin D. Blessing.
Did they just come to America and get banned from all Walmarts? That would be hilarious.
Nelson for the grievance administrator.
And good morning, Your Honor. Luther Glenn, appearing pro se.
Hey, citizen.
Morning. This is a pre-hearing conference pursuant to MCR 9.115 F4C, being convened virtually via Zoom video conferencing before Tri-County Hearing Panel number 15 of the Michigan Attorney Discipline Board in the matter of grievance administrator B. Luther W. Glenn Jr., P number 38683, case number 24-77-GA. The panel is comprised of me, Lynn Helland, chairperson, Patrick McLean,
hey, Lynn.
member, and
hey, Patrick.
John Cawthorn, member.
Hey, John.
The panel has been appointed by the Attorney Discipline Board, the adjudicative arm of the Michigan Supreme Court, for the discharge of its constitutional responsibility to supervise and discipline Michigan attorneys. Counsel for the grievance administrator is Austin D. Blessing Nelson, who will present the case for the Attorney Grievance Commission.
Let me just tell you, Mr. Blessing, he takes his job very, very, very seriously.
which is a separate branch of the Michigan Supreme Court for the investigation and prosecution of discipline matters. As this is a hearing being conducted via Zoom, hosting controls of the meeting will be performed by the case manager, Jody Grow. The hearing will be live streamed on the board's YouTube channel, and the parties are asked to avoid excessive over-talking and interruption to keep the proceedings moving smoothly. This hearing will be conducted according to MCR 9.115, the rules for circuit court bench trials and the Michigan Rules of Evidence. In accordance with MCR 9.115J, the hearing panel must first determine whether misconduct charged in the formal complaint has been established by a preponderance of the evidence, by respondents' admissions, or as the result of respondents' default for failure to answer the formal complaint. If, at the conclusion of these proceedings, the panel determines that misconduct has not been established, the proceedings will be concluded and the complaint dismissed. Upon a finding of misconduct, the hearing panel will conduct a separate hearing to determine the appropriate discipline. At that time, the panel will consider evidence which is admitted for the purpose of showing mitigating or aggravating factors. The decision of this panel may be appealed to the Attorney Discipline Board by the grievance administrator, the respondent, or the complainant. And we will now proceed with the hearing. Mr. Austin.
I think I'm going to show another very, very lawyerly, lots of lawyerly stuff, trial. It's only a 1 day. It's not like a full day. It's just a short little thing, but it's in front of Judge Reese. So there's a whole, Judge Reese is sitting on the bench, and there's a whole panel of judges in front of him. And what I think happened, but I'm not 100% sure, is they had a trial in front of Judge Reese, and whoever he ruled, and one of them lost. So then they took the case to the Supreme Court. No, they took the case to the appeals court, and I think the appeals court sent it back to Judge Reese. So they are fighting for a whole new trial over this. So a whole big panel of judges comes in front of lawyers, comes in front of Judge Reese and tries to fight the reason why the way he ruled the first trial was wrong. And because of this, he needs to do a whole new trial. And it's a lot of law talk and everything like that, but it's still Judge Reese. So it's like very, very, very professional. And then he says, something Southern or something, or a funny story or something like that. So what I'm going to do is put this out separately. I'm not going to put it in a live, so you guys have to sit and watch it, because I promise you, I know the attention span of most of you, and it will be very difficult to play this in a chat, in a live stream. So yeah, Judge Reese is just so fun to watch. So yeah, I'm going to put that out separately. And I am getting another Kelly trial out, I promise.
Mr. Blessing Nelson, I'm sorry. Let me begin with you.
Sure. As a preliminary matter, I just want to point out, it was brought to my attention that unfortunately there is a error in paragraph 4 of the formal complaint. It says that Mr. Glenn became licensed in 1982 and lives or works in Cass County. Unfortunately, that is incorrect. It should be 1986 and Wayne County. Fortunately, it appears the correct hearing panel was assigned. I apologize for this mistake. I would request that that be deemed amended. I can file a new one if need be, but I would ask that that date back to the original filing date.
Mr. Glenn, any objection to amending the complaint?
Well, I was defaulted in this matter, and I filed a motion to set aside the default. I would respectfully ask the court to require that the complaint be amended and the panel accept my filing to the answer.
Okay, so breaking this down into its separate parts, I hear you have no objection to amending the complaint.
Well, as long as the default is set aside. So,
Okay,
Yeah,
well, I'm going to, I'll deal with those two questions one at a time. Mr. Glenn, I then understand that you object to amending the complaint. Is that correct?
correct.
Okay, can you explain to me how you are prejudiced by amending the complaint?
Well, it's amending it without formal pleadings on this matter. The allegation and the complaint goes straight to it has parties in jurisdiction. So, in my opinion, that's not a small area in the complaint. That's something that needs to be formally amended.
Okay, let me just ask either of my panel members to disagree with me if they're so inclined, and we'll go to a breakout room. But my inclination is to grant the motion to amend the complaint on the basis that this is an amendment in form, but not in substance.
I think we have to talk about this.
Yeah,
Okay.
can we go to a breakout room?
Yep.
One moment.
Michael, are you telling me I need a nose job?
Are you there?
yes.
No, that's not the bad news.
And Ms. Kaminsky, are you ready to proceed?
Sir.
All right, a couple of things. One, it was pointed out to me when we went off the record that the opening statement I read actually applies more to a hearing. I want to clarify, this is a pre-hearing conference that we're having today. It is not the actual hearing.
I had wondered about that. It did seem like there was some misconduct hearing language there.
Yeah, that's on me. I was reading the wrong language. And we also had a chance to talk through the situation with respect to the complaint. We now have a new complaint. And because we have a new complaint, there is no default.
No, under the court rules, amendments can date back to the original filing.
Well, okay. I think I go ahead and make your argument.
Okay, court rules.
He wasn't ready to actually
Okay.
make an argument,
Just find the
Judge.
court rule. I have it cited here. Where is it? 2.11. Let me find that.
He didn't think he would have to prove his case. He thought it was all, it was just one digit.
Just give me 1 second to find the court rule, because I had planned to use it, but I'll
Whether
just
it dates
say-
back is irrelevant. He still has to answer the amended complaint.
You'd have to answer the amended complaint, but only to the extent it's been amended. I'm amending one paragraph. I'm not amending the full thing. Here we go. Amendments.
If he timely answers your amended complaint,
No, that would not undo his default. MCR 2.118, specifically I'm seeking under 2 to amendment it. MCR 2.118A4 amendments. Oh, wait. I'm sorry, 2.118D. An amendment that adds a claim or defense relates back to the original pleading if the claim or defense asserted in the amended pleading arose out of conduct, transaction, or occurrence set forth or attempted to set forth in the original pleading. I mean, honestly, it doesn't even directly address this. I'm not adding a thing.
no, you're not adding a new claim.
No, and there's nothing in here saying it doesn't date back. And honestly, I'll be completely honest, did not have to come in here and I offer to amend this. I could have left Mr. Glenn to his proof. And contrary to what he said, he did not file a motion to set aside the default. The default.
Well, let's not proceed to that because we're still talking about whether or not the complaint has been amended. And I'm not hearing a court rule that clearly says that the amendment dates back to the original and doesn't affect the timing of the proceedings. So
there's no court rule saying it doesn't.
Okay, but that's not going to work for us. We're going to want a court rule that is clear. Otherwise, as far as we're concerned, we have a new complaint, and that requires an answer. And Mr. Glenn has an opportunity to answer it.
MCR 2.118B, response to amendments, reads as follows. Within the time prescribed by MCR 2108, a party served with an amendment to a pleading requiring a response under MCR 2110B must, 1, serve and file a pleading in response to the amended pleading, and serve and file a notice, or serve and file a notice that the party's pleading filed in response to the earlier pleading will stand. So the court rule puts the onus on the respondent to respond. But he does get to do that. So if you're going to amend, that's fine, and we think that's probably a good idea. But
no, in that case, I will respectfully withdraw my motion to amend. I'd ask Mr. Glenn that he make a motion. Quite frankly, here's where I'm at. Quite frankly, Mr. Glenn filed an answer to the formal complaint pointing out a single defect in my formal complaint. He filed an answer that admitted 3 paragraphs, but improperly claimed lack of knowledge to the rest of the formal complaint. The answer is not proper. The default.
But he answered
you asked on the record. You asked on the record to amend your complaint.
I did, but I did
on the day of hearing.
I asked to amend it to conform with. I asked to amend it to correct what, quite honestly, was an unfortunate typo. This hearing panel was properly assigned. I asked to amend it on the understanding that it would date back and not affect the default, which quite honestly relates to Mr. Glenn's professional obligations.
Why do you need a default in this case anyway? Why can't you just prove your case?
That's neither here nor there. I'm entitled to a default if Mr. Glenn does not timely and properly answer the formal complaint. He then has an obligation to set the default aside. I could prove this case about the default.
We all understand that, but an amended complaint's a new complaint. And if he answers it timely, it's at issue.
So that's where we are.
Okay.
So we're not comfortable with defaulting the respondent when there might be some substance of a response. We want to hear the merits, not technicalities. Anyone would.
Mr. Blessing Nelson, I know you're not real enthused about this, but for what it's worth, I think it's probably to your benefit that we dot every I, cross every T, and let this process play out with every I dotted, every T crossed. So that's what we're going to do.
Okay, I respectfully disagree. It's in the sake of judicial economy for default, but I respect the panel's decision on that. And okay, when should I file the amended complaint by?
Well, I think you amended it today. I mean, I guess I would consider.
We haven't seen it yet. He's going to file a piece of paper that's an amended complaint. He described it for us, but we haven't seen it.
Okay, let's file it today if you can. Let's get the process moving.
I can try to get it filed today. Yeah, I would ask that the panel set a deadline for Mr. Glenn to respond to that body.
The court rules do that. He has X days to respond to a complaint. If he's late responding to your amended complaint, I'll be flabbergasted. But if he does that, he could be defaulted again.
Okay.
Mr.
Okay.
Mr. Glenn, respond to his amended complaint timely, please. Do that.
Yes, sir. Yes, sir.
And
don't
just to
want-
clarify, is it the panel's interpretation of the court rules that Mr. Glenn has to respond or has a right to respond to the entire formal complaint, including changing his original answers to things that I'm not amending?
You can always do that. When there's an amended complaint, you can always raise whatever you want to raise. Now, if there's inconsistencies of what you have said before, that can go to credibility, that could be raised. You can certainly point out later, if it's to your advantage, that Mr. Glenn has said X and not X. But he has to respond to your amended complaint, which he hasn't seen in writing.
Okay,
Okay.
I can file that today.
Okay, and yeah, and whatever day you file it, whether it's, we're not setting a deadline for you to file it. But whatever day you file it, he has what the court rules provide him to answer it. We trust that he will. And then once there's an answer, whatever it is, we'll take it from there.
Okay, and just to make sure that all our T's and I's are crossed and dotted, is the panel formally setting aside that default? It's being deemed moot.
We don't think we have to deal with that because you're amending.
Respectfully, some ruling needs to be made on it. It has been filed. Whether or not the panel deems it moot, to preserve the issue, if I do decide to file an appeal, something needs to be ruled on.
On the record, you asked to amend and we're letting you.
So I would say that your amendment moots the default and the motion to set it aside.
Thank you. And just for the record, no motion to set it aside was ever filed. And that does need to be in writing because it needs to have a statement of meritorious defense.
I understand there was a motion.
Yeah, I have here a motion to set aside the default that I
One was
received
filed this morning.
this morning.
It's very short.
If that was filed, it was not properly served on me because I never received it.
Okay,
It's going to be mooted by
Right.
your amendment anyway.
Right.
Correct, but I would just want to know that that was not properly served on me and should not be considered. It
Okay.
is moot, but
And we're
for the
not
record.
granting that motion to set aside. We aren't considering it.
I know, but
It was
to make
filed.
sure record's clear, that motion was not served on me. I just want to make that clear.
Okay. All right, but Mr. Blessing Nelson, it's better this way. The Attorney Discipline Board doesn't want to hear hypercritical, hyper-technical arguments about default procedure. It's going to want to know what happened or didn't happen here.
Respectfully disagree, but I defer to the panel.
Okay.
And Mr. Glenn, this is gratuitous, but I hope you've heard the conversation we've had about timely filing, proper service, and as we move forward, those are issues we won't have to deal with.
Yes, sir. Understood.
All right. Then unless there's anything further, I believe we are done here today.
I would request that we set a hearing date.
Well, do we need an answer to the complaint before we do that?
Well, I'm filing it today. He has, I believe, 21 days to
21
answer.
days.
So we'll know within 21 days if he answers or doesn't. Regardless of his answer, I mean, given the allegations, I'm not going to need any more time to prepare based off his thing. I request that we set a hearing date and some motion deadlines, and get this ball rolling.
Well, okay, I think we all agreed to get a ball rolling. How about, though, what we do is, and again, my co-panelists, tell me if you feel differently. Well, I think we should set a pre-hearing conference date so we can understand what this eventual hearing will look like. I'm not sure we can do that until we have an answer to the complaint.
And a complaint, because there's no statute of limitations at all. And in theory, the complainant could wait a long, long time and then file an amended complaint. So let's have an amended complaint and an answer within 21 days. Now we're all set.
I mean, if that's how the panel proceeds, I'm okay with that, but just to be clear, I am representing to you that I'm filing the amended complaint today. It will not be filed whenever. I'm also telling you that based off the allegations in the formal complaint, which are straightforward and relate to failure to answer RIs, that I can tell you exactly what the hearing will look like, how many witnesses I will have, the type and number.
There is no complaint now because it's a moot point. There's no complaint right now.
Type and relative number of exhibits that will exist and everything regarding that. And Mr. Glenn has already seen the formal complaint, which will be amended with one single paragraph. So I respectfully think we could set all the deadlines and stuff today, but if the panel wishes to do another pre-hearing, I will defer to the panel on that decision.
You know, we know that it's in your interest to get it going fast. We expect you to file it today. We're not saying we don't believe you won't file it today. We think you will, but maybe Mr. Glenn will hire counsel. Maybe there will be another set of eyes on the case. Let's do it right.
All right. That I agree. I dotting, T crossing. We're going to move this along, but we're going to do it a step at a time.
Look at his stress
Okay.
grabbing.
Thank you.
That,
All right. This hearing,
at least he didn't start crying like the guy, like the guy in the earlier stream was crying when he didn't get his way. Okay, now the bad news. So for some reason, Judge Fleischer's stream is not on YouTube today. I'll show you. I might as well show you. But I have a different idea. So if you look at Judge Fleischer's stream, today is not there. I don't know why it's not there, but it's not there. I thought I was gonna get my hands on a copy. I'm gonna look one more time to see if it's here yet, but I didn't see it yet. I'm looking one more time because it takes a while to download. No, I didn't get a copy. I thought I was getting a copy, but it just takes so long to download. But I do have something in my other folder. So this is Judge Fleischer
Give me like a list of
from,
criteria as are wanted for one reason or the.
so before, this is Judge Fleischer from before the, remember he took all of his stuff down and then he started over. So there's only like a couple of streams on his site right now. This was from before that. I don't think we saw this whole docket. So I thought what we would do is watch the rest of this docket. I'm hoping we didn't see this whole docket. We might have, but we'll find out soon. If we did, then the stream is over. If we didn't, then we can just watch this and finish out the stream. Sound good? Plus, he looks so nice today. Camping. Oh, no. Wait a second. Oh, I see something I'm not happy with. See this right here? You guys see this right here? Oh, boy. Is that the subset? Did we already see this? Because isn't that the subset right there? Well, I'm going to press play and just see what happens. I have a feeling, though, that we've seen this.
Kurt Cobain's MTV Unplugged guitar, 6 mil.
Yeah, the Dreadnought, Martin.
Didn't he play a Jaguar? I think he played a Jaguar.
Was it Jaguar?
Oh, well, I know that that's the electric was a Jaguar. I don't know
Yes.
what the.
Yeah, but the Unplugged was I went to a pawn shop in South Congress. And then, yes, I got it. Yeah, I got it pretty cheap. I don't think they realized that.
Yeah. Give me a second, Colin. Marco, what's up, bud? How are you?
Judge, how are you?
Oh, you got a plea?
Yes, on
Real
Mr.
quick.
Molina.
Ready? Is it me or Juane?
Carlos Molina.
Oh, that's not.
We're pleading on DWI and they're dismissing the mischief judgment made restitution.
I don't. Oh, Carlos Molina? Yes. Okay. Carlos Molina.
Molina, ¿qué tal? ¿Pares aquí en la mitad? ¿Qué tal? Me llamo Luis César, con mucho gusto. Hermanito, solo mire, después si le contestan nada más en español. Cualquier pregunta que tenga su licenciado. Su abogado, perfecto. Gracias.
Good morning, Mr. Molina.
Buenos días, señor
So
Molina.
you're charged with 2 cases. You're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You're facing a year in jail and or a $4,000 fine. You're also charged with theft. On that one, you're facing up to 6 months in jail and a $2,000 fine. You guys have worked out an agreement. They're going to dismiss the theft in exchange for your plea on the DWI. You need to understand that the DWI
Just a reminder, we're not going to bash any other channels at all.
will go on your record. It's going to be there forever. What do you think will happen if you got pulled over after a night of drinking and an officer sees a prior DWI in your record? What do you think is going to happen?
¿Qué cree que le va a pasar a usted? Regreso a la cárcel. I'll return to jail.
I would never, even if you've had one beer, get in a car because your record will kill you. And what we're doing today, you'll be facing a minimum of 90 days in jail if you ever pick up another DWI. Do you understand?
¿Entendió, señor?
No more proverbial slaps on the wrist. You're facing, like I said, up to a year. You've worked out an agreement. They're offering you 3 days in jail. Credit for the 3 days that you've done.
Dice cárcel, crédito por los 3 días que ya cumplió.
It also says here $650 in restitution.
$657 en restitución, él ya pagó eso. Sí.
And that was on the theft case.
Y eso fue el caso de uno.
Bruce Rivers is a YouTuber who featured Judge Fleischer, and I did not watch it, but from what I've heard, he did not say the nicest things about the judge. But I didn't watch it, so I don't know. I do not know. I think that it's a good idea if we do watch it and leave our own opinion for the people who look at his comments. But I have not had time to watch it and appropriately respond yet. But we can't do that here. Ugh, Anthony, you're gonna get banned. You can't just repeat words like that. You're gonna get banned, and I'm not gonna stop them because those are the rules.
Lo de robo.
Great. That's good. Good. I'm glad that you paid that.
Me alegra que lo haya pagado.
It's only fair.
Es solo justo.
Always the idea
Todo
here,
la idea
whenever
aquí,
there's someone that there's an alleged victim in a case, we want to make them whole again. And so thank you for doing this. That's great.
ahora sí, bueno,
You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do?
¿Qué desea hacer? Yes.
How do you plead to the offense, sir?
Se declara la ofensa. Guilty.
I will find you guilty, sentence you to the agreement. I'm going to suspend your license for the minimum, which is 90 days. Do not drive until you get a license. Otherwise, you will be right back in here with us.
Señoría,
You can if you want, but you'll have to get the dates to them. Okay. All right.
You do know I have to live with him, right? Oh, gee.
Good luck to you, sir.
buena suerte.
Thanks.
Thanks.
Thank you.
Yeah, bring him out. Oh, okay. Bring him out. I got a plea and then 2 CJ's cases coming out.
I guess let's do the plea
Wait.
while they're bringing them up.
NWA NNE.
NWA.
Is it Nguyen? Wayne?
Wayne.
Wayne?
1A. The N is not.
Order in the court for plea.
You'll go right here. And that's, you don't have to put anything. She's gonna pay anything. It doesn't have that. It's what the current cost. That's verse 4.
So
I'm not sure about the meeting, Judge.
what do you do with yourself these days, Ms. Swanee? Sorry? What do you do?
I work at Whataburger.
Okay. Are you sure you want to do this? You realize it's going to go on your record.
Yes, sir.
You realize you're only making life more difficult for yourself, right? The more convictions you have, the more difficult you're making life. I mean, you need to understand that life doesn't get easier as you get older. It gets more difficult, and the more convictions you rack
She works at Whataburger, so she has clothes on. She definitely has her shirt on.
up, the harder life is. Just not many people are going to give you a job if you keep getting convictions. So no, I guess you don't want to do a deferred.
I asked her about it, Judge, and I told her that she could avoid the conviction. She didn't defer. She has no convictions that I saw. She said that she wasn't interested in that. I mean, if you're.
There is a type of probation that if you complete successfully, you don't end up with a conviction on your record. But that would be at a minimum, 9 months. You got to stay clean, no alcohol, no dope.
Order in the court.
You've no interest to try to keep this off your record?
Got a job.
Stephen, after 2 times of yelling at them in the gallery, I think you need to tase some people. Uh-oh. Where did our Sovsik go? What happened? I missed it. Darn it. It's all right. We'll find out.
Keep myself busy. So
Great.
I plan on staying out of trouble and staying out of the way.
But nevertheless, you're not interested in a probation to try to keep this off your record? Are you sure? Okay. You need to understand that this is going to go on your record. Once you plead guilty, you can never change this. This is a lifetime decision that you make today. The other thing that you need to understand is that if you ever run from the cops again, because it's an evading arrest, which is an enhanceable offense, they can use, if you ever pick up another one, they can now make it a felony offense instead of a misdemeanor, because they can use this to enhance you. You understand? Okay. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change it. So are you sure you want to do this? There were no other offers, I guess, no PTI, anything like that?
No, Judge. The circumstances following the.
Okay. If you change your mind within 30 days, perhaps we can do something if you get buyer's remorse. Typically, but you got to understand, this is not a good day for you. This is not a good thing that's happening to you. You're only hurting yourself even more. Do you understand? Stop picking up convictions. Stop getting into trouble. All right, you know that from now on, it's a minimum of.
I don't remember seeing her again since this day. Does anybody else remember? I don't think so. I think I would remember.
90 days in jail, minimum of 90 days for anything you pick up. All right, how do you plead to the offense? Guilty or not guilty? I will find you guilty, sentence you to, is it 3 days?
2 days credit for 2 days.
Oh yeah, okay, 2 days in jail, credit for the 2 days that you've done. I will roll your court costs so you won't owe anything. Good luck to you, Ms. Warren. Okay. Thanks.
You have Mr. Gonzalez and Mr. Rubio, they're both, Your Honor.
Okay. Gonzalez
This is
Rubio.
Gonzalez and Rubio. Yes, sir. I gave to.
Good morning, gentlemen.
Buenos días, señores. Buenos días. Good morning.
Both of you guys are wanted from other states, and you're being,
¿Qué está haciendo?
Order in the court, please. I can barely hear the judge and I'm right in front of him.
you're being brought out because you guys are wanted for one reason or the other. You are Alejandro Gonzalez.
¿Ese es su nombre? Sí. Yes.
You're wanted for out of the state of California for receiving stolen property, motor vehicle, unlawful driving or taking of a vehicle, resisting, obstructing, delaying of a peace officer or EMT.
Demorando policía un paramédico.
Are you waiving formal extradition?
¿El señor?
Are you waiving formal extradition?
No, I just signed.
Did you want the 14 days for them to come pick you up?
14 días para que ellos vinieran a recogerlo a usted? Sí. Yes.
And you must waive formal extradition.
Extradición formal. Sorry,
American courts in the house.
I didn't know. Usted ya habló con su abogado, señor.
I guess. You have,
Bill, I don't think the today's stream made it yet, so I just used an old one that you got me.
Well, I think he's understanding the question.
Thank you.
He lost the translation, Judge.
Pregunta.
You want me to ask him?
¿Quiere que yo le pregunte? Mire a su abogado.
¿Vas a renunciar a pelear que te extradicen? No. ¿Sí o no? No es ok, es sí o no.
Eso, si digo sí,
es lo para que te vengan en 14 días.
es lo que más. Sí.
you want to waive formal.
Oh my God, Superman can speak Spanish too?
¿Renunciar a extradición formal?
Sí.
Yes.
Mr. Rubio, you are wanted out of the state of Tennessee for first-degree murder.
Asesinato capital.
Are you waiving formal extradition, sir?
¿Extradición formal usted?
Okay.
Hablar más fuerte. Yes.
Okay, guys, we wish you the best of luck. Take care, and we'll wait for the respective jurisdictions to come get you.
Thank you.
Las jurisdicciones a buscar.
Yeah, yesterday's stream is still today for me because I haven't gone to bed yet. So when I say today, 50% of the time I mean yesterday, and then 50% of the time I mean today, and you guys get to kind of figure it out. Fozzie's usually here to figure it out for y'all, but I think he's sleeping and we're going to let him sleep. Nope, you're just going to have to get quicker, figure out what today means.
Brandon.
Morning, Judge.
Hey, man.
Your Honor, I'm here on Mr. Enriquez. Judge, this is he was on a, yes. Your Honor, he was on a DWI. He had to come back to prove that he did his IoT SOP classes. I believe he did, Your Honor.
Ouch.
Oh, $930.
Come up, Mr. Enriquez.
Yeah, Judge, he does have the.
So are they withholding all certificates until he pays it?
So these are the supervision fees, so all the fees associated with the program. I don't know if they want to waive the fees, so we could be done today or.
I asked, I just emailed Brenda, and Brenda said they can't get information. According to her.
The moment you pay these fees, the moment they dismiss these cases, when can you pay these fees?
I'm not sure. I don't want to give you an exact date and not fulfill with it, so.
He told me in the hallway potentially 2 months, Judge. They asked for a 4-month extension. Could we get 2 months?
He's going to be under bond condition during that time as well. You know, you're going to have to pay. The longer you take, the more you're going to end up paying in the long run because you're going to have, what do you have now, an interlock?
He has
spam.
Soberlink. All that costs money. The longer you take, the more.
That's why I've been backed up on it. PL told me it would talk to y'all about, dropping it or potentially reducing it.
Tried, but it's not up to me. It's up to the DWI. It's their program. It doesn't run with me. They're the ones who file the dismissal. They're the ones who, write the terms. I only do the resets and either grant or deny the reset, But at some point, we need to put this baby to bed. It's 710 days old. We can't just keep it open forever. What are you doing with yourself these days? Are you
You know,
working?
I'm a waiter at Papacitos. I mean, I'm just doing what I can right now.
So pick up double shifts.
I mean, I tried to, but, you know,
I worked at Papacitos, I made a killing.
me too, but I mean, I be paying off my bills and stuff.
Where do you live?
What was that?
Where do you live?
I mean, I live, with, my parents right now. I be paying them bills.
You're living with your folks.
Yeah, but I mean, it's just like if I'm living by myself, I have to pay rent, other things, utilities, so. I mean,
You
everything.
pay rent with mom and dad?
That's right.
So if I call your mom and dad right now and I ask them if you're paying rent, they're gonna tell me yes? What's the number? Let's do this. I need to give you a deadline to have this done.
I
We
understand.
can't keep this open forever. It's on you, if you need to, get a second job because you're living at home. Are you doing anything else besides working at Papacitos?
I mean, I just cut hair on the side. I mean, I got my barber's license, but
Okay, barber's license is not, you're gonna have to perhaps get a third job and then, but you need to do what you need to do to get it done. I'm not gonna hold it open forever. I'll give you 30 days, but it's already 710 days old. I'll give you 30 days. If you don't have it done by then, I'm gonna set you for trial. We can't keep going. You need to do what you need to do. Are all the fees from what? And when was the last time he made a payment? That's unacceptable.
Like the last payment I see was November 14th, 2023.
He was paying for the classes. He was paying for the IP.
and then the breathalyzer and all of that too.
The fees are for drug testing, supervision, the assessment fee. and-
I've had third jobs often.
The $300 for the assessment fee.
But it's been 2 years.
A bit over a year.
Well, since you said what?
November 14th.
Yeah, it's been a year.
Was the last payment.
It's time. You need to get this paid. Start working double shifts, do what you need to do to get more money. Okay? So we'll give you 30 days. You got to come back in 30 days and see where we are. If you've not made a payment in 30 days, things are not going to go well. You understand? Okay. All right, guys, I'll see you in 30 days. Hey, you ready? Hey.
Judge, I was approaching again on Dr. Roger Byrne, one from Florida.
Okay.
He had some people coming over from, on Friday, as well as having trouble getting a flight direct. So what he's done is if we could set it for bond forfeiture on Tuesday, he has a flight confirmed for that day to come back for his first.
He's flying in on that day and we're going to have court on that day?
He's got a, yes, sir. He's got a 6 a.m. I told him that. He said he'd,
That's not a wise move. Every time that happens, Murphy's Law dictates. You know what I mean?
exactly. I do. I'll tell him that he's having a lot of trouble getting flight. There's a lot of pressure on Southwest Airlines. The flights coming in and out of there right now because of the hurricane that went straight through there.
There's no other flights?
Well, there are. I'm just saying, but it's on him, right?
You said he's a plastic surgeon, right?
Used to be. He's an old retired plastic surgeon now.
Did he sell the practice?
I don't know, but I bet.
Typically, what they do is they sell the practice for millions and millions of dollars.
They
So,
don't. You know, they spend as a doctor. They're worse than lawyers. You spend every dime they ever make.
well, that's not, it's not what you make. It's right.
If we could set it for that Tuesday for bond.
I will give you that, but after
I
that,
also filed a notice of appearance as well.
we got you. But let him know if Murphy's Law and he's not here, no more extensions.
I'm with you.
It's on him.
I'm with you.
Done.
Thank you.
Thanks, Frank.
See you Tuesday.
See you. Hopefully.
Well, I'll see you. I might be in here begging you.
No,
Sorry.
no.
But I
No.
told you.
As much as I love you,
I know Your Honor. It's a
Hi,
feeling.
Jen.
I'm telling you,
it's an honor and a pleasure.
Always.
JL, are you ready?
Judge, I think I need a selfie with this.
Please.
Well, we're working on it. There was a miscommunication, but we're almost there.
Okay. Sam? Hey, What's up?
Hey, I'm here on Marcus Richards.
Oh,
No.
I'm gonna bump it forward until we get someone besides a lawyer in front of him.
someone who doesn't want to be found. Are we
Michael?
I reached.
clear?
Stated to
Oh,
the
there we go.
at the vehicle.
Oh, man, he's strong. Where's Steven?
Probable.
Judge, thank you for the courtesy. I appreciate it. This is,
Hanging out with our
I love the decorations.
do you want to bring up
Listen, children, eat your spinach. Eat your spinach, and you're gonna look like this guy coming up.
your client?
Mr. Lopez. And you should have a report, Judge.
All right. Good morning, Mr. Lopez.
Terry's in
Mr.
the
Lopez, you're
house.
charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent.
You are now Fozzie Jr. You did it to yourself.
Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
One more, Your Honor. On September 6th, 2024, officers were dispatched to an assault.
Do you know Micah? Micah said he would never fly with me. Isn't that sad? I don't know. Some of him looks like Popeye. Terry.
At a residence in Harris County, Texas. Officers made contact with the complainant. The complainant was picking up a DoorDash order, returned to her vehicle, and removed an empty cup and placed it on the floor in the parking lot. The complainant stated that the defendant grabbed the cup, threw it back inside the vehicle, and the complainant placed the cup outside the vehicle once more, and the defendant grabbed the cup, placed the rock inside, and the defendant threw the cup with the rock at her, striking the left side of her face, causing pain. The complainant stated the defendant grabbed her windshield wiper and the two engaged in a verbal altercation. The complainant states the defendant grabbed a handgun from his vehicle, held it by his waistband, but did not point it at the complainant. The complainant stated that the complainant stated to the defendant that she was enrolled in a police academy.
Litter is important to fight against, guys. Fight against litter.
Was calling 911, and that's when the defendant left the scene.
Okay. Mr. Lopez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. If you violate these conditions, I'm going to put you in jail. You will not get any more PR bonds. Understand? Yes, sir. See that there's no bond set now.
Correct.
You guys want to do?
It's just a misdemeanor, Judge. We're looking at 500 to 1,000.
Okay. What do you think?
We're going to post it to 1,000.
Okay. We'll set it at 1,000. Do you have any open cases now? Are there any open cases now? All right, I will give you a PR bond now, but I'm going to tell you, Mr. Lopez, this is it. I'm not going to give you another one. You violate conditions, do something you're not supposed to. I'm going to do everything in my power to protect the public in every single manner, however I can. So beware that we have eyes on you now.
Reps
Any
of
false
100.
move, we're just going to put you in jail. You understand? You know, you're lucky. One false move with that gun, because it's very tempting. You could be hit with a second-degree felony. God forbid someone else didn't have a gun. I was reading a report yesterday or a couple of days ago where same kind of deal, two people getting at it, one blew the other away, dead. You never know who's on the other end of that argument and whether they have a gun or not. Got to be careful. Life's way too short for this. For now, I'm going to have you sign a resale with Victoria. We'll get you with pre-trial for your bond and your paperwork, and then we'll have you sign your bond conditions, and then you'll be on your way. You have a lawyer, so we will waive your appearance, but it's your responsibility to stay in touch with JL, and she'll tell you when you have to come back to court. If she tells me she can't get a hold of you because you're gone or you're ducking and dodging phone calls, I will issue a warrant for your arrest. Pick up a new case, violate conditions, same thing. Do you have any questions? Just be nice. It's not hard, you know? All right, guys, please.
Thank you, Your Honor.
Thanks, Jan.
May I be excused?
Yes,
Judge, did you set the bond?
1,000. Granted a PR bond, and then no contact and no weapons. So if you can file that, please.
Fine, I'll pull her.
On Saturday.
No, September 20th.
upon, I don't understand why you are still pushing your luck. You were supposed to register immediately upon doing the 3 days as a condition. When did she do the 3 days, please?
September
Terry,
20th
thank
is when she
you.
went in. And that Monday, I think, it reinstated her judge.
September 20th.
She did, she was released on when, the 21st?
23rd is when she was released.
Released the 23rd. She was supposed to register immediately, starting the IOP. And what day did she register?
Yesterday.
Because her probation officer told her she had a month.
I told you here what you were supposed to do. I'm tired of playing this game, Andrea.
At least
I'm
she's
tired of playing this
registered.
game. It's
Mr.
like,
Sapien?
you know, when this is what happens when you're too nice. It's over and over. People take advantage of you like crazy. It took 1, 2, 3, 4 weeks for her to sign up for IOP, Andrea. 4 weeks.
Can you, since she's already registered,
No, I mean, I'm done with this. I'm just, what?
let her see if she goes, if she attends? I don't have I don't, there's not much that I can say. I don't have much to stand on.
She
But
doesn't take us seriously.
hoping that you will allow, since she's already registered, you'll allow her.
Let's do this. Let's do this.
Because she has an ankle monitor on. That's on. It's
I'm
on.
gonna send her for a drug test right now. I want to see what if anything that she's gonna test positive for. And then right now, I want to send her for a test. And then I guess we'll talk when she comes back. Because first things first, I want to know if she's clean. If she's not clean, it's over. That's it. But if she's clean, then we'll talk about how we go further.
Did I
But-
send her back here?
Uh,
How long, so I know how to manage everything else. that
I
I
have your cell phone, right?
Yes.
I'll text you when she comes back.
Okay.
And I don't know. Just take a seat for me, man.
Thank you, Judge.
Thanks, Andrew.
You should hear what my daughter has to say about how we say hi to each other. F-bombs and screaming and yelling. She really, really, really gets upset with the way we say hi to each other. All right, let's find one more. I hope it's not a yellow shirt. But if it is, that's fine. You know, if it's a yellow shirt, we can watch yourself sit again. Hey, Victoria, are you getting dressed? Is that what you're doing right now? Wait, let me check the camera that I put in your house that you didn't know. All right. Joking. I didn't put a camera in her house, although I was in Texas. Oh, there we go. Not yellow shirt. Yes, sir. This is the last one, even if it's short or long. Here we go.
Since we've reached what we consider an acceptable agreement with the state, subject to the court's approval, and I understand that you'll want TRAS part of that. And
Are you want to do the PTI agreement?
I'm sorry.
PTI?
Yeah. I don't know if it's going to be that yet. We're subject to the TRAS.
What do you want?
Victoria, what are you wearing? You can send the picture in Discord. We'll see.
Want to do?
Well, she was
know.
telling me that you had a condition for TRAS, and that's why I'm
Probation or for what?
probation.
Okay, it's up to you
I just
guys.
wanted you had them in the box and all that. I just want to make sure that.
So, well, the only thing I'm going to advise you, Mr. Durham, is that you're on bond in this case. It's old, and now you have a bond violation for
I love
missing
fudge.
a drug screening. I will give you a pass today, but this is the only one I'm going to give you. If you ever miss another drug screening and they,
Guys, so we have to go now. I need Kathy time.
Call you to go take a test and you fail to go, I'm going to revoke your bond. Do you understand? You were expected to abide by the bond conditions like everybody else, and when they tell you to go test, you have to go. If you fail to go, then
Yes, sir, and I did apprise him of that.
I'm not gonna give you any more passes.
Everybody go into my comments, not this chat, my comments, although you could do it in this chat too, and say happy naked birthday, metal rules. Happy naked birthday.
So you only get out of jail free card you get.
Thank you, sir.
It's up, if you guys want to do a probation now, we can do
You know what? Because we love metal so much, we should all just be naked today in honor of his birthday.
it now, and he can just do the TRAS as part of the probation, or you can do the TRAS first, whatever you guys would like to do. I'm amenable to each.
He's a good guy that got in a bad spot, nothing to really help.
Okay, it's up to you, however you guys would like to handle it. I'm game with whatever you'd like.
Yes, sir. We appreciate it.
Sure.
We'll do the TRAS first.
You want to do the TRAS now?
Yes, sir.
Okay. So since he's here, we might as well send him now. That way we
Yes,
can
sir.
kill two birds with one stone.
Yes, sir.
This is an evaluation to see what kind of conditions
Man.
they would place on you for being on a DWI probation. So that way you kind of are informed of what to expect entering into the probation. If you didn't want to do the probation, you'd have to do another offer. You'd either accept a jail time offer or we would set up a trial. So those are the three different options that you'd have. And I don't know what kind of jail time offer they would give you. That's on them, but
Yes, sir.
subject to us accepting it, of course. But
Yes, sir.
this way,
Hey, Christy's here. Hi, Christy. Also, a humongously big shout out to Texas Vernon. I saw you commented again and I lost it because I missed you. And I'm so happy you left a comment. Really, really, really happy.
this would give you kind of a look into what requirements you would need to do to successfully complete a probation. So
Yes, sir. We appreciate it, Judge.
since you're here, there's no better time to send you now. And then, so what we'll do after that, we'll set you off after today, 3 weeks to give you time to get the TRAS back, and then we can talk about how to go forward.
Yes, sir.
Don't miss any more. Okay?
We won't do it. Thank you so much. We
Take care.
appreciate it.
Yeah, Alex's discovery complete on Durham.
All right, guys. Thank you very, very, very much for coming out today, and then earlier today, and then, yesterday, and then I think it was, anyways, thank you for coming out for each one, no matter when they were. I appreciate it. No, I have to because my eyes are getting, look, this is I don't know how many is coffee and it's it's not helping. I really, really, really want to get to Judge Fleischer's court today. I'm I, and I if I don't get any sleep, I have to get some sleep. Sleep has to happen soon. Somebody said to me today that when they don't get sleep, there are they can't do words. And that's almost to the point that I'm at right now. And you know what happens when I get really sleepy? I say the wrong words at the wrong time to the wrong person. And it only takes me to say one thing wrong and this whole thing is over. I get canceled like that. I'm ready for it. I deserve it. So I also think I should tell you guys, I'm starting a different YouTube channel with my niece. It has absolutely nothing to do with courts. So I just felt like I don't know that I was lying if I didn't tell you. I don't know why, but because she wants to start her YouTube channel, but she can't do it by herself. So she asked me to join her, and it has absolutely nothing to do with court videos. It's her content. I'm just there to talk to her. So there. Now I don't know when it's going to start. I don't have any information about it, and I'm never going to bring it up again. But now you know. So I didn't lie to anybody. Tasing. No, let's not tase. Let's sleep. Let's take a little nap and get ready for Judge Fleischer's court. See, Victoria is halfway through getting dressed right now, just so you know. We don't know if her bottoms are on and her top not, or her top's not on and her bottom's not. can't feed the cats yet. It's only 6:30, Kelly. You have to wait 30 more minutes. No, I'm buying myself a whole rubber outfit. That way I can't get tased, right? That would work, right? If I like made an outfit out of a tire or something, or the rubber in tube inside the tire, I think that'll work. No tasing. My son tased himself because he wanted to know what it felt like. My son also maced himself because he wanted to know what it felt like. I don't want to know what either of those feel like. I'm never going to do that to myself. Never, never. Yes, rubber. All right. Go to bed. I will see you in 2 hours, 3 hours, something like that. If I wake up. Oh, I got to wake up. Somebody wake me up. Where's my outro? Bye, guys. I love you so much. I will see you soon.
Got these lights that goes digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted, sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes mirror a sky so blue. In her jokes, there's a truth so true. With extreme, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted, sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted, sharp. In a way, there's no alarm.